In this video I want to look at the different types of charity there are in the UK and draw out some similarities and differences between the way charities or non-profit organisations are incorporated in the USA and the UK. In the USA there is a system of incorporation of non-profit organisations via the individual state, that is, one of the 50 states of the USA. This enables certain types of non-profit organisation to function like private companies founded for business enterprise, but in order to qualify for this status, the non-profit organisation must be founded for charitable purposes. In the UK, there used to be a comparable system of incorporation of charitable and voluntary organisations via a local authority, but this has fallen out of use since the 1970s, and particularly since the late 1980s. This is because what was then a new type of charity was created in the UK, that of the charitable company, which took the legal form of a certain type of generic private enterprise company, provided that it was founded for exclusively charitable purposes. Prime Minister Margaret Thatcher was lobbied by various large charities and voluntary organisations who wanted the ability for their organisations to be able to engage in general trade so that they could raise money directly from charity shops on the high street, for example, without having to maintain a core charity side to their operation and a separate fundraising company side, which would be their trading arm. Legislation was passed in the UK Parliament in the late 1980s to enable a charity to register as a company limited by guarantee with no share capital, provided that the charity's name, objects and aims reflected its exclusively charitable purposes, as set out in its constitution, which is termed a Memoranda and Articles of Association. The main point for the moment is that a charity could use a certain type of legal off-the-shelf model for its legal framework, which would give the charity all the powers and responsibilities of a corporate company under the Companies Act 1985 as a freestanding legal entity. Charitable companies, just like private enterprise companies, are like corporate individuals. They can open bank accounts, employ staff, they can sign legal documents, and they can borrow money in the same way as an individual citizen can. Charitable companies are regulated in the first instance by the Charity Commission, who regulate all charities in most of the UK, but they are also regulated as companies by the government's regulator of companies, which is Companies House. Charitable companies register with Companies House under a special rule that they are founded and engage exclusively in some kind of outdoor or other type of social work which reflects their charitable status. In total there are 5 types of charity in the UK, and they are: firstly, charitable companies; secondly, charitable trusts; thirdly, charitable unincorporated associations, sometimes known as an unincorporated voluntary organisation or association; fourthly, friendly societies; and lastly, charities formed by royal charter by the Queen or previous monarch under the royal prerogative, and these can take legal forms similar to any of the previous types mentioned, and where they do so, they form a special case within that category of charity. There is a new type of charity in the planning stage, and this is the Charitable Incorporated Organisation, and it is being introduced by the Charity Commission and the Office of the Third Sector, which forms part of the Cabinet Office, which is administered by very senior civil servants and presided over by the Prime Minister. The Charitable Incorporated Organisation, or CIO, will have 2 legal framework forms. Firstly, a foundation CIO, which will be somewhat similar to a lightweight version of a charitable company, similar to a charitable trust. Secondly, an association CIO, which will be somewhat similar to an unincorporated association, but it will be incorporated. The reason for the proposed introduction of the Charitable Incorporated Organisation, CIO, was that too many small to medium-sized charitable companies found that they had a great deal of difficulty meeting the requirements of understanding and complying with both charity and company law when it came to drawing up their annual report and accounts for inspection by both these regulatory bodies. Many small to medium-sized charitable companies, in the view of the charities themselves, the Charity Commission and Companies House, found that they did not have the expertise or resources to actually understand the legal implications and ramifications of the charitable company as a legal framework, as they considered it to be far too complex legally and financially for them to effectively get to grips with. This has led to a demand for a simplified version of the charitable company, which both regulators and charities consider would suit charities' needs better. This is why both the Charity Commission and Companies House have been so ineffective at tackling regulatory issues relating to the financial and organisational running and management of charitable companies. In particular, the methods by which the trustees of the charity, who are also directors of the charitable company, are elected or appointed. In my view, it is not only the charities that lack expertise in this area. The regulators do as well. The Office of the Third Sector relied upon the Charity Commission to produce a draft model constitution for the CIO for the purposes of consultation with charities, but the original draft document did not contain any clauses about the appointment of trustees or directors, because it only included provision for the small group of individuals who they thought would found the organisation to occupy the role of trustees or directors. This supposed oversight by both the Charity Commission and the Office of the Third Sector in its supervisory role meant that the founding trustees would continue in office indefinitely, as they could not be replaced, as well as the organisation not being able to recruit new trustee directors. This obvious blunder has been rectified to a certain extent during the consultation process with the charity and voluntary sector about the government's proposal for a new kind of charity, but it speaks volumes about the lack of skills and essential knowledge and know-how on the part of both the Charity Commission and the Office of the Third Sector.